Start.
Yes. Okay. Good afternoon. I have not received any question till now. So last week we discussed about patent, novelty grounds. So any questions from that side? I have not received any question till now. So last week we discussed about patent, novelty grounds. So, any questions from that side? I have not received any question. So last week we discussed about patent, novelty grounds. Okay, so no questions till now, I think. Okay, so another important aspect is inventive states that as referred as not obvious to the person's skill in the art. So what, just like you consider novelty means no prior knowledge, no prior claiming, no prior publication, no prior working, and last also discussed about absolute novelty concept. So inventive steps, there are different kinds of tests are there, just like we call it TSM test, teaching, suggesting, and motivating states. Problem solution approach, generally we also follow, just like novelty, we are deciding based on solution based on prior art background. So now solution should not be obvious to the person's skill in the art. Just like if you a doorknob made of metallic, you found a lot of corrosion and other things are happening, you want to shift it to polymer, almost fulfilling the purpose of the metallic knob, then that is obvious to the person skill in the art and may not qualify the criteria of inventive steps. Similarly, if two prior art suggesting you, teaching you, suggesting you, and motivating you to do some modification, that modification should be considered obvious to the person's skill in the art. Skill in the art generally consider person having average knowledge in that specific field. Person having average knowledge in the specific field. So there you get a teaching, suggesting, and motivating test. Then following another test, problem solution approach. Problem. So patent is to provide some solution with reference to functionality regarding process or product or process along product by improved process. So that are the basically patent. Just like software cases we consider in the form of a system. Those are the things. Part. And last criteria is capable of industrial application, capacity to be used on industrial scale. What do you mean by industrial scale? Industrial scale means repeatable. Repeatability. It should have repeatability. Not like that you one time you produce some compound, so next time you will not able to produce that API. API is active pharmaceutical ingredient. So that's the things. So that's the capacity of using. Then we have a section 3 that has been considered to safeguard the socio-economic perspectives of India. Like method of agriculture is not patentable. Similarly, section 3D, 3E, 3Fs are there. 3D to prevent evergreening in the pharmaceutical industries. Similarly, 3E, 3F, arrangement, rearrangement, all those aspects are there without increasing efficacy, without providing some efficacy, is considered not patentable. Similarly, 3K, computer program per se. This is one of the things. Per se interpretation is as such. Computer program as such is not patentable. As such is not patentable. Computer program along with the hardware is patentable. There was say, if you follow the guidelines suggested, hardware is need not to be novel. Need not to be novel. Hardware is don't require to be novel, but using that software algorithm, you are providing some sorts of functionality, improved functionality of the hardware, Just like recently 5G systems are coming, so they are also have a lot of algorithm, mathematical method for improved functionality of some component. So there are also a lot of algorithm softwares, computer program. Software means computer program will come up. Okay, so see that if you analyzed patent along with copyright, industrial design, trademark, all together, that in respect of patent, the infringement will be considered based on novelty. Novelty, just like and novelty means novelty means, let's say he is using your invention. Just like if you analyze the infringement in reference to the copyright, they call substantial similarity. So there is no concept of whatever have been there in patent inventive steps. Similarly, when you consider trademark, we have deceptive similarities. Deceptive similar use of plaintiff trademark by defendant is also leads to the infringement if it is a registered trademark. So that's the thing. If you criteria, if you take together all patent, copyright, trademark, and similarly in industrial design also, the infringement criteria is called substantial similarity of the surface pattern and ornamentation as applied to the article of the plaintiff. If it is reflected in the defendant articles, so then it is lead to the industrial design infringement. And the criteria now to registration purposes, if you consider industrial design new or original. Interesting interpretation is that new in that specific class. Original means originated from authors. Originated from the author. Qutub Minar in the shape of a pen may be novel and original. So new and original. New in that class, original by means of application. Just a Qutub Minar shape no one has been may have been thought about for the pen. You have first decided to consider Qutub Minar shape pen. So definitely it will be considered as new and original. New by new in that specific field means class or the writing instrument. Original means originated from you. So that's the interpretation, new or original. Similarly, there are also, if you mere mechanical contrivance, then which is artistic work to take care of the separation between the copyright and industrial design, which is artistics are not, which are mechanical, just like functional aspects. Those are not a subject matter of industrial design, but just like where solely mechanicals, not aesthetic. That part, nice way, case laws are there to decide it that okay, there is an aesthetic features is there along with the mechanical features, mechanical contrivances, then that may qualify for industrial design. Other cases, no. So similarly, so there is a industrial design registration procedure. The authors or assignee can register. Similarly, we have a cancellation proceeding. There is no pre-grant or post-grant opposition for industrial design. Section 19 mention about the cancellation of the industrial design grounds as specified by section 2D, definition of the design, section 4 referred, which is not considered a design. So all those grounds also can come up for cancellation of industrial design. So this is here also the section 46 is there, just like section 35 in patent, and partially you may consider section 4 also, atomic energy related aspects. So here section 46 related to defense, industrial design and defense purposes. So there is a clause for section 46, also important part for any person who want to practice in IP field and industrial design part. So that is also one of the aspects are there industrial design. Then if you come to copyright, interesting legislation, their concept lies with reference to originality, concept lies with reference to authors and owners, concept regarding infringement, concept regarding fair use. Those are the important aspects. Just like you consider original work of authorship, copyright protect original works of authorships. So, and what are the rights provided by section 14 of the Copyright Act? Right to reproduce, right to copy, right to translate, right to adopt, right to communicate, all of multiple rights you will get in section 14. And originals means definition suggested, originals mean interpretation, not definition, interpretation from the code. Independent creation, not copied. Then further, based on case law, it has come up, based considering industriousness doctrine, West versus rural telecom industries case laws. There it has been mentioned as fruit of just like Lockean philosophy, that sweat and bro type of doctrine, that industriousness theory, or sweat and bro type of doctrine, just like sweat and bro. When you are reading something, first sweat is coming on your bro. Sweat and bro type of doctrine, just like say a defendant in that cases collected the data independently and came up with a similar type of telephone directories. So they applied sweat and bro type of doctrine and created as an original work or originalities. Then there is another doctrine has come up, modicum of creativities. Some minimum level of creativity should be there in the reference to the work, copyright work. And you know the different categories of copyright work, starting from literary work to musical work to artistic work to dramatic work to cinematographic film. And computer program is treated as literary work under Indian copyright law. And literary work, if you consider that literary work is considered by 3 criteria, it means it should provide some information, instruction, pleasure. Just like what is the characteristic of literary work? Literary work means it should provide some information, instruction, information, and pleasure. So that is the criteria for literary work. Similarly, musical work, in musical arts, in reference to definition, is in reference to India, it is called notes and tones, not accompanying word. But in reference to US copyright law, definition suggested musical work includes accompanying word. So if you consider song includes have musical notes and tones along with the accompanying word. In our cases, musical notes and tones separate, lyrics is separate. So lyrics may come under the purview of literary copyright and notes and tones come under the purview of musical work. Similarly, dramatic works, work in action. Cinematographic form will come up, moving image. See that's how categories of work differs from one to other. So moving image, their image work in action. So they are moving image, not the persons, moving image. So same dramatic work may be converted into cinematographic film. So there are case laws are there regarding that how dramatic work somebody adopting into cinematography. This can be considered adaptation. Adaptation in the form of cinematographic film. So that lead to the infringement of the copyright of dramatic work. That's the thing. So that these are the copyright. Similarly, trademark part, I still could not get any questions in the chat. Then if you consider trademark is specifically already referred to reduce the transaction cost, search cost. It based on the two theories, source theory and quality theory. It provides the functions of source and provide the functions of qualities, just like a source indication function. If you read this lab, so Reddy's lab will be considered as a trademark, and say if some logo is considered trademark, that is signifying that the source of the specific product coming from there, and ultimately it provide say a single anonymous source and unchanged quality of the product, There also you will get the definition from section 2ZB regarding trademark. You will get the definition regarding mark from section 2M. You will get mark includes. You get trademark means. So mark definition is inclusive definition. In the mark definition, level, packaging, everything has included for the trade dress has come up. New area have been coming up in reference to trademark and mark, like sound, smell, that will satisfy if they satisfy the criteria of graphical representation. Because India, we follow the graphical representation requirement. So if graphical representation requirement followed, then only they will allow to register as a trademark in India. Just like a musical work will qualify the to be registrable trademark based on the notes and tones. Smell may be qualified to be a trademark based on the chemical formula, which is providing that specific smell. Based on that, you are distinguishing goods and services of your undertaking from the others. So that's are there in the reference to trademark. And you have to read the section 9, section 11, section 12, specifically considering absolute ground of refusal of registration of trademark. If somebody want to practice, you should know the section 10 regarding limitation of the color. If you want to consider trademark for a specific color, then your rights will be limited to specific color. If you don't put any color, black and white, then your rights will be open for any combination of color. So that's the choice. Then section 11, the relative grounds of refusal of registration of trademark. Then 12, absolute, honest and concurrent use. Section 13, chemical or IUPAC name and trademark. Section 14, person living and trademark concept. So those are the things will be applicable during the registration of the trademark. Again, when you come to section 18, most probably 18 with tells about that 18, 19, that also come on as a prosecution part during the registration of the trademark. Then you have to should read section 28, 29 regarding that rights of the trademark owner. Say 29 for infringement. 27 also you read passing of an infringement part. Then you should read trademark say assignment along with or without goodwill. I think 37 on that part. You should read section 46 registered user concept. All those things you should read when you are studying the trademark in reference to that prosecution transaction part. Then if you consider infringement, enforcement of trademark, then so 29 is there. Then further you have to read from 101 onwards all. 134 tells about the jurisdiction. 101 tells about the falsification. Like this, all the sections you should read regarding the enforcement. perspectives. Okay, so regarding similar way copyright, you should read 51, 52, infringement, fair use, provision, what is considered as a fair use. 52 is specified that infringement aspects and procedural aspects, jurisdiction, remedies and others are also there. Industrial design, copyright, trademark, these are the things. Then if you come to another legislation, geographical indication, difference you will get, this is considered as a community right. Difference you will get that it is not, say, transferable, just like a trademark. Also, a trademark, copyright, so it is not transferable. There is a concept called Part A, Part B registration. This protect the right of the community. It is a tool for rural economic development. It is a tool for skill and traditional knowledge protection, positive protection. So that way you will get the difference. A registration procedure based on product place link. The person has to produce evidences of product place link based on the historical background or based on some agroclimatic soil condition, just like Darjeeling teas. So then you have to provide a geographical map, you have to provide a uniqueness. So those are the different things you have to provide in a GI1 forms, along with what are the indication you try to use, just like here you are using the Darjeeling tea or Darjeeling tea logo or name Agra Petha or Pashmina or Chanderi sari, like this is a specific indication. That's indication you are want to use for the product. That is there in geographical indication aspects. So and then similar say criteria is like say for indication criteria like a trademark. What are the indications? Just like mark you can use as like a mark in trademark. So that way, that dispute lies in reference to trademark versus GI. You should read Article 22, 23, 24 of the TRIPS agreement. And this is very interesting aspects of social aspects, social economical aspects, and along with the legal aspects, how the division regarding protection of the geographical indication across the countries and what are the till debate with reference to Article 23, 22, and how 24 take care a little bit of the debate part and how the things are moving for geographical indication. Similarly, IC layout design is there also, that there you will get the legislation in reference to India in 2000 enacted, and now I am expecting a few more registration in IC layout design registry will come up. It is governed, it is administered by Ministry of Information Technology, MIT, Ministry of Information Technology. So there are criteria, if you see that the criteria is staple criteria of industrial design criteria along with the trademark criteria as a new or original and distinctive things has come up in IC layout design. There also registration procedure is very simple. Period of protection is 10 years. Similarly, industrial design period of protection is 10 years plus 5. You can extend the corporate or industrial design for another 5 years, or 10 plus 5, 15 years. So that is IC layout design. So there you should read the criteria required to register industrial design as a IC layout design. Then here also you can transact your right. Here if you see that that enforcement part that somebody incorporated your IC layout design in a hardware, then that also leads to the infringement, and importing that also leads to the infringement of IC layout design, your IC layout design. And registration is compulsory, just like the industrial design registration is also compulsory. Here also registration is compulsory. Wherever copyright and trademark registration is not compulsory. So that's the IC layout design aspects, IC layout design aspects. Then, so another part is their plant varieties protection. Another is their trade secret, although no specific legislations are there. We protect trade secret by, say, Contract Act. We protect trade secret by, say, common law, just like unfair trade practices. So on that part, trade secret is protected in India, although maybe there is a requirement of specific legislation for that. So US, they have a federal legislation, Uniform Trade Secret Act. There, so we don't have, but we are taking care of that based on Contract Act and common law nice way. So that is the trade secret. New uniform distinct varieties, uniform stable and distinct variety can be protected by virtue of say plant variety protection. Just like two varieties are there, farmer varieties and breeder varieties. Farmer varieties means traditional variety. Breeder variety means that new uniform stable. That's the criteria. NDUS, new distinct uniform stable. That's the criteria that they are for the plant varieties type of protection. So these are the important aspects of the different forms of IPs. Now I will take few questions from that, from the participant side. You can ask the questions right now from the discussion, whatever held or whatever assignment you have already completed, whatever I think I have shared reading material, initial portion to one person. I told him to share all the things to others also. Further, I will share few materials, reading materials. I have shared the patent office, patent manual, although that is open to all document available from the website itself. Further, I will share few more material to you for your, say, assignment purpose, appearing in exam purpose, and yeah, all the things. So now we will take few questions from participant side. So if any questions are there, is open to all. So any questions? Okay. So no questions are coming, just then I can take another 5, 10, 5, 6 minutes for discussion. Then as per guideline, we'll stop the discussion. Okay, so I think we have covered the things like criteria for patent, criteria for industrial design, how one person, just like one important aspect if as a, for managers is that auditing. So how can you distinguish that a creator came to you? So you have to tell which is the form of protection he should avail or he will get for dual protection. So that sorts of things you should now be in a position to guide. So this is the this for this reason this course is useful. Just like an art, say a knife, knife, if you provide cutting edge different ways to, let's say, to cut different varieties of fruits. Nice way of design, nice way you have given the functional aspects of the tip of the knives. Just like say, if you want to cut different say fruits, you understand that textures of the fruits, the sharpness and other kinds of things, without destroying the fruits. You may have to give some functional design to the knife cutting edge. So that part make definitely functional aspect, definitely will come under the purview of patent. Now, if you give a aesthetic look to the handle, so that it is providing aesthetics, its aesthetic value of the knife is also increasing. So then you should suggest the client, you should go for a patent protection for that part and also go for industrial design protection for that part. There is no problem. The court has referred the scope and nature and scope of protection by the each forms of IPs are different. Just like if you consider copyright is given you right to copy, trademarks is use. Somebody is using your trademark without your permission. It is a registered trademark, it is infringement. It is unregistered trademark, it leads to passing off. It leads to passing off. So that way, the scope is different. Just the same label and logo will be protected by trademark and copyright also, but definitely by the same person. If it is a right of the different person, then maybe a problem. Just like you know that when you try to register some artistic work like logo and others, you should take say NOC from the trademark registry before registering under the copyright. That this is not a trademark of somebody's. So that the procedural aspect have been taken care of, so that multiple people is not getting rights over the same person. That is available for that things. Similarly, the patent aspects we have not discussed. Important aspects is there regarding patent applications, patent filing, content of the application following the section 10, 12, sufficiency of the disclosure, how to write claim. If somebody want to qualify a patent as an examination, essential things that you should learn, how to draft a specification that content different aspects like title, object of the invention, field of the invention, statement of the invention, description, description with drawing, claim, and abstract. Those are the elements required in Form 2 of the patent application. Similarly, Form 1 tells about the things, inventor, applicant, title. So definitely that things are there, that how the title will be framed, how the claims will be drafted. These are the skill-based things, practice-based things, that these things will come up based on practice definitely. So that's practice will tell you how to go about the things. These are the important part of IP practice, that you will sharpen your skill based on practice regularly in reference to prosecution, how to give answers regarding office action, in reference to litigation, how to draft the plaint, and further the reply evidences, means if regarding the plaint, against the plaint, how you submit to reply. So these are also an important. All those specific drafting formats are there, but you have to follow. You will learn how to further prepare the things gradually. So those are the things we are we learn from the subject, from the discussion, from the participations also. So I again could not get any questions from in the living chat also. So just wait for 2-3 minutes. Okay, as no questions are coming and as per guidelines, then we can close it here. So thank you for participation. If any questions are there, you can drop mails in the mailbox. We are regularly addressing any question and addressing the questions on a regular basis. So please try to participate by writing, by chatting, whatever means you can think is feasible or you deem fit. So I think we can close, no?
Yes.
Okay. Okay, then thank you. I'm leaving.